My lord, appellant's name is CD Equisearch Private Limited, but the learned stenographer has written RE, so certified copy section is not taking the application. My
We'll show it in the days list and correct it.
Yes,
Pratu Doria.
move from 25th August.
My lord, I'm praying for leave on the appellate side, my lord.
Hmm.
This is a very urgent matter, my lord. The concerned, my lord, petitioner is an advocate of this honorable court, my lord. After 18 years of marriage, my lord, a false case has been foisted upon him.
Now,
and his
what do you
family
want?
members. My lord,
What do you want?
my lord, I prayed for leave before the learned single bench, my lord, single judge, my lord. He has refused to entertain, my lord. Interim protection is required because of section 35.
I can't do anything on the administrative side.
My lord. Anyway,
How to? You once again make a request.
no, my lord, and I'll file it then, my lord.
You file it then.
Anyway, your lordship, fare thee well. Before leaving this court, your lordship, very pleased to meet your lordship in this
Yes,
court.
sir. Pleasure.
It has been a pleasure.
Pleasure is mine also.
My lord, I leave to file an mat without a certified copy. I have applied for the certified copy.
Date of the order?
My lord, 3rd September.
3rd September. Yes, leave that.
If your lordship may kindly permit me to mention one IT-80 matter, lordship has taken the matter lastly on May 19th. Thereafter, lordship, it has not come up in the list. If your lordships may kindly fix one date for hearing, lordship.
No, there is no date available.
Kindly, lordship, one just, it won't take much longer.
15th, I won't be able to do any much. So we are hardly left with 2 days.
My lord, I humbly.
Lordship, another, lordship, just a small innocuous prayer, lordship, seeking a modification in one order, lordship.
What is the mistake?
Lordship, just a date, single date, lordship, page 3, 7th line, lordship. The search and seizure procedure was conducted on 3rd December 2014. It has been noted as 2024, lordship. Just
2014.
14, lordship.
This is a appellate, original side matter.
Lordship.
Days list, it will be correct.
Grateful.
Humbly mentioning, my lord.
That wagon
That-
matter.
Yes, my lord, because entire bar also waiting for this judgment because that's very important issue is involved, my lord. Because already your lordship applied your lordship mind and
Only one judgment we have reserved. That is almost ready.
my lord, it can be concluded in the court itself, my lord, because it's a very already your lordship concluded the mind. That is the only one.
Let us see. Let us. You please give the number.
Yes.
Yes.
Get one.
My lord, did not give any adjournment in my case, my lord. I have to go to the Supreme Court, my lord. But in the order, it has come 2 months adjournment. Supreme Court is open, my lord. So kindly.
After vacation. We adjourned it by 3 weeks. Because of the vacation, it will come in the first week of November.
Actually, my lord, there is no vacation in the Supreme Court. I am late. So let it be the list, my lord. I will get the file. Let it be the list without the file. I will get the file, my lord, from the department. If
No,
there
no.
is a requisition.
We can't advance the date. You file an application, let us see. Please call.
So, can.
Original side daily list item number 1.
But I am appearing in this case. But there is a delay of 944 days. Also, my lord, the tax effect is, my lord, less than the prescribed 1 crore 61 lakh.
Appeal has been, sir, please take down. Sit down, sir. This appeal has been filed with revenue under section 260 cap clear of the Income Tax Act 1961 within bracket TI. Challenging the order passed by the Income Tax Appellate Tribunal C Bench Kolkata within bracket tribunal ITA number 32/KOL/2022 for the assessment year 2017-18. The revenue has raised the following substantial questions of law for consideration. Question number 7, para 7, page 5, A, B, and C.
The tax effect, my lord, is mentioned also at page 7. Paragraph 9, my lord. You mentioned.
We have heard so and so. There is a delay of 944 days in filing the appeal. The order impugned passed by the learned tribunal is dated 18th of April 2022. Certified copy of the same was received by the Income Tax Department on 12th of May 2022, and the appeal ought to have been filed not later than.
My lord, appeal ought to have been filed, my lord. 14 September
14, 2022,
Yes.
but was filed on 10th April 2025. We have perused the affidavit filed in support of the application for condemnation of delay, and we find that no cogent reasons have been given except to state that the file moved from one officer to another. The delay in filing the appeal having not been properly explained, we are not persuaded to exercise any discretion in favor of the appellant department. Apart from that, the tax effect in the instant case is
My lord, page 7, paragraph 9, 1 crore 62 lakhs.
is rupees 1,62,62,812, which is well below the threshold limit. Therefore, for such reason also, the revenue cannot pursue this appeal. For the above reasons, the application for condonation of delay in GA number 1 of 2024 is dismissed. Consequently, the appeal stands rejected. The substantial questions of law suggested are left open.
Grateful, Your Lordship. Okay.
New application tax matters item number 2.
Exam for the respondents, my lords.
There's a delay of 147 days.
I have directions, I have instructions to oppose the delay, my lords.
What is the issue? 68.
It's a penny stock matter.
As there are certain important facts in relation to Vivad se Vishwas ki, my lords, that has to be brought. My lords, may kindly allow me to file the reply. Although, my lords, I have not filed my wakalatnama since the clients were outstation, and I had received the brief just on last week, my lords.
147 days is delay to
As I'm not talking about the number of days, my lords, there are certain important facts, my lords.
Now, what happened to this Namokar builders?
My lord, in this case, Nalanda Builders judgment was relied upon in Namukar. Nalanda Builders had filed a appeal. Assessee went for Vivad se Vishwas.
This Namokar, you didn't
Namukar, I am not aware, my lord.
any appeal had been filed against that because
on
the
the-
tribunal has only quoted that decision.
Yes, my lord. And there's a issue point. Tribunal held that the no cross examination was given. On that,
Pardon, use the mic.
no cross examination was given to the assessee. On that point, my lord, was decided in the Nalanda Builders case, my lord. But that issue has covered by the my lord judgment of Swati Bajaj. And these two penny stocks, my lord,
No, what the tribunal says is the department could not controvert the factual position being similar to Namakar.
and in Namokar, my lord, Nalanda Builders was relied upon. My lord, page 35, my lord.
So if you come to page 56 bottom,
My lord.
paragraph 11. From perusal of the findings of this tribunal, we find that the same is squarely applicable on the facts of the instant case, and the learned department representatives having failed to controvert this fact, decision of tribunal in Nalanda and Namokar are squarely applicable on the facts of the instant case. Therefore, respectfully following, they allowed the appeal.
But Nalanda was my challenge, my lord.
That is challenge, but
Well.
then it went before. But Namokar has not been challenged. But the department could not controvert the factual position, is what the tribunal records.
My lord, is find the order, my lord, in Nalanda's, my lord, that has been cited in this order, my lord. The only ground that was the violation principle of justice, natural justice, because no cross examination was given. And these two penny stocks, my lord, find mention in the report that 84 stocks.
Yes.
That is at page 37, my lord.
There's no substantial question of law, my lords, involved. my lords.
But here also, what is the name of the company where the scripts were?
Page 14, my lord. My lord, these companies are, my lord, Blue Circle and CCL International.
Pardon?
Blue Circle and CCL International. That is at page 34, my lord.
Page
34. Or 33 and 34 in both pages, my lord. 33 is clear, my lord.
BCSL and
Yes, my lord. CCL International. CC International.
So the tribunal proceeded on the basis that
Yes, my lord.
cross-examination was not
Not even.
permitted.
Yes, my lord.
But then, sir, if you come to page 43, there also Blue Circle Services Limited was the subject issue.
That is also on a cross-examination, my lord. And there were, my lord, can you come to page 44, my lord? In para 37, in middle portion, my lord. Para 37, middle portion. Since the AO has only disallowed the claim of bogus loss, it in itself means that the genuineness of purchases of equity share of Blue Circles.
What is the tax effect in this?
My lord, it's a penny stock, my lord.
37 lakh.
Tax effect is less than 50 lakhs, my lords.
My lord, that is covered by that
Yes, tax effect is absolutely
circular.
Covered by the exception. There's
Yes, my lord. My lord, here what has happened?
See, now, when the tribunal records that the department could not controvert the factual position, what are we to do here?
My lord, here
That is the problem.
my lord, this case,
That is why he is right in saying that there is no substantial question of law.
my lord, here the facts of that Nalanda Builders and Namukar's case has been discussed, my lord. Not about.
as the factually the tribunal has settled the.
My lord, kindly see the concluding part, my lord.
No, you show that
My
the
lord.
facts in Nalanda was different from the facts of the present case. But Nalanda also concerned that blue circle.
My lord.
So that is why the tribunal says the factually.
Blue circle, my Swati Bajaj.
They cannot.
Swati Bajaj case also blue circle.
All right, let him file his wakalatnama. Let us see. You want to file an affidavit in opposition?
My lords.
We have heard so and so, so and so. Mr. So and so accepts notice for the respondent assessee and craves leave time to file wakalatnama as well as affidavit in opposition to the prayer sought for condonation of delay. Let the matter, let such affidavit be filed within 3 weeks from date. Reply if any within a week thereafter, 2 weeks thereafter. List the matter after 5 weeks.
However, my lords, there is no substantial question of law, my lords. My lords.
Not now. That is our interpretation. We may change. Item 3 is also same.
Same assessee, my lord.
Same assessee, same order, separate order. Next.
Item number 4.
Item 4, then we have the SSC method.
Lord,
I
here
didn't
is
serve with the copy yesterday.
Lord, delay of
Filed the wakalatnama.
You have yet to get the copy.
243 days delay, my lord.
What is the issue?
My lord,
Same
my lord,
penny
issue,
stock.
issue is my lord 263, and my lord, the tribunal, my lord, of the view that earlier occasion also, my lord, the AO, my lord, examines the papers and document, but my lord, after, my lord, when the, my lord,
Where is the tribunal's order?
my lord, tribunal's order is page 44. Now the page 47, the Millard, the following Millard 1, 2, 3, 4, the queries of the Millard PCITs.
Oh, we restored the matter back to the tribunal.
Yes.
Page 47.
47, that is the Millard query of the PCITs.
Observe
One,
the
one,
SSC has not made proper and adequate inquiries. Been sent only as test check. Extract of the bank statement which reflects only impugned transaction. directed to examine, etc.
Now, paragraph number 5, it states that the assessee has produced the details. And below the tribunal,
There were only 9 share applicants.
Milord,
He has issued notice under 133(6) to all the 9. All the 9 have filed confirmation, and they have also responded to whatever queries were raised.
now that is the factual finding of the tribunal. Tribunal finding is not in favor of the revenue. But your lordship kindly see the assessment order in terms of 263 order, the assessment order passed. Your lordship kindly see the assessment order for a glance, milord. That is appearing in page 13. From page 15, the statement has been recorded. Thereafter, your lordship kindly see from page 18. But these are the allotted companies. So your lordship kindly see the last second paragraph of the first allotted company, Devdarshan Vinimay Private Limited. On perusal of PL account found that receipt of such and such has been shown against the expenditure of rupees such and such and has claimed loss of rupees such and such. All the 9 companies has loss running companies. All have incurring loss on that assessment year. They are making investment upon the assessing company. Furthermore, your lordship, all are same. Now let only your lordship kindly see page 23, paragraph number 10. In these cases, there was no compliance from the end of 6 alleged subscriber companies mentioned above, and detailed document furnished by 3 allotted companies is not, in my opinion, satisfactory, wherein C. J.K. Jain as a director.
But that is not the question, Soman. Whether 263 was rightly invoked is the issue.
263 was the issue. 263 was rightly because your lordship kindly look into the 262 order, page 60. It starts from page 65. But here specific case of the PCIT that money has been routed back. There is investigation report. The investigation report also sent to the AO. AO did not make any inquiry. Kindly see page 67. Second paragraph, on significant developments in interim since the passing of order such and such, it has been that investigation under section such and such carried out by the investigation in Kolkata in the case of several such companies on database prepared basis of information and complied in a series which contain hyperlink, which have statement of entry operator and dummy director of the sale companies. It was deposed by them before the authority that the amount credited in the account and subsequently transferred from them did not belong to them, proving that the companies were paper companies. Such information gathered during the course of investigation was passed to the AO for information action or further investigation. Before first, when the scrutiny assessment was passed by the AO, AO did not consider anything. That's why 260 order been passed. Thereafter, after the 263 order, when the AO taken charge and making inquiry, AO find that 9 allotted companies, they are all running in loss. How can these companies purchase share of a company? Even the one interesting fact, the company, SEC company, it was incorporated in the year of 2008. And 2008, in the assessment of the year 2009-10, he raised share capital of 10 crores, amount of 199 million premium.
Where are your questions?
My question is, my lord, that from page 6,
Today we will condone the delay,
As your lordship pleases.
and then the appeal can be heard.
But we have not filed the wakalatnama as of now. That's the only
Oh.
difficulty. So
but let them liberty may be given, me to file vocal, delay may be condoned.
not have any
You have heard so and so, so and so. So and so accepts notice for the respondent and craves leave to file wakalatnama. Leave granted. Leave granted as prayed for. There is a delay of 243 days in filing the appeal. As the explanation offered is acceptable, the delay is confirmed. Application in GA 1 of 2025 is allowed.
Deep here.
For admission of tax matters, item number 5.
I am for the appellant, my lord.
Hmm.
I have come against the order passed by the appellant, ITAT, my lord,
Hmm.
imposing cost of rupees 50,000 on the ground that I did not comply before the appellate authority, my lord. But my lord, if your lordship kindly see once the appellate order, my lord, it has been dismissed for default without considering my grounds, my lord, in violation of section 250, subsection 6 of the Income Tax Act, my lord. Paragraph 6, my lord. Page 24. Small glass soap owner, my lord. Kindly see the order, appellate order, my lord, page 20. It starts from page 20. And my lord, the appellate authority noted the dates which has been communicated to the petitioner appellant, my lord.
Hmm.
Thereafter, my lord, the certain judgments were quoted. And thereafter, in view of these facts, page 22, I am of the opinion that no interference is called for in the AO's order, and therefore the grounds of appeal are dismissed. What are the grounds of appeal? Nothing was discussed, my lord. It is gross violation of section 250, subsection 6 of the Act, my lord, which says you have to determine the points of, my lord, law, and thereafter you have to pass a region order, my lord. Kindly see, my lord, section 250.
But what is your explanation
My lord, I have
for non-compliance on 3
my lord, I have explained, my lord, that petitioner appellant before the, my lord, the tribunal was sick, my lord, fell ill, my lord. Therefore, he could not comply. Thereafter, my lord, what happened? He is an individual, my lord. He is dependent upon his accountant, my lord. So when he informed the accountant, my lord, he did not comply, my lord. But even, my lord, that even if I do not appear, my lord, kindly see section 250, subsection 6, my lord.
But even before the AO, you did not.
Yes, I did not. My lord, the only issue is, my lord, during the demonetization period, my lord, 13 lakhs cash was deposited. This is the only case, my lord. I am a small shop owner, my lord. I have the cash, my lord, in the cash book, my lord. The Income Tax Appellate Tribunal, my lord, allowed me to participate before the assessing authority. But, my lord, this cost is, my lord, too harsh, my lord, upon the appellant, my lord. Kindly. Before the appellate authority, my lord, the documents were uploaded. He could have considered, my lord, my documents, my lord. Kindly see section 250, subsection 6, my lord.
You read?
I am reading, my lord.
Sir, Income Tax Act.
The order of the Joint Commissioner disposing of the appeal shall be in writing and shall state the points for determination, the decision thereon, and the reason for the decision. They do not have the power to dismiss for default, my lord. But if your lordship will go through the order, my lord, it's a dismissal for default, my lord.
But now the tribunal has sent back the matter to the AO.
Yes,
but cost alone.
Cost is, my lord, affecting me, my lord. Kindly consider.
And what is the nature of business?
My lord, glass shop owner, small glass shop owner. He is running the business, my lord. It's not a fly-by-night operator, my lord. And he filed the return of income, my lord, declaring income of rupees 3 lakhs, my lord.
No, this was deposited during the demonetization period.
Yes, my lord. And I have the balance, my lord, in my cash book, my lord. It is not the case, my lord.
Where are your appeal grounds? You have got that file?
No, file has. I have not brought, my lord.
But before the tribunal, you said non-appearance was due to
Illness, my lord.
But,
I stated in my this stay petition also, my lord.
page,
Page number, my lord.
ill health, poor knowledge regarding online compliances,
Yes.
and sole dependency upon the consultant
Yes. Yes.
who did not comply with the notices.
Yes.
But no one is appearing, my lord. Your lordship kindly direct me to appear, and my lord.
Sir, please come. This appeal has been filed by the SSC under section 260 capital A of the Income Tax Act 1961, within bracket the Act, challenging the order dated 15/7/2025, passed by the Income Tax Appellate Tribunal, SMC Bench, Kolkata, within bracket Tribunal, in ITA number 738/KOL/2025 for the assessment year 2017-18. The SSC has raised the following substantial questions of law for consideration. Page 7 and 8, paragraph 15, questions 1, 2, and 3. We have heard Mr. Anil Dugar, learned advocate, appearing for the appellant, assisted by Rajshri Chatterjee. No? Advocate for the appellant SSC. Full stop. Though notice has been served on the respondent department, no counsel has been nominated by the department. Therefore, we have directed Mr. Soman Bhattacharya to accept notice on behalf of the respondent department and his appearance be regularized and the fee bills be honored. Para. This appeal is directed against the order dated 15/7/2025, passed by the tribunal, by which the learned tribunal had remanded the matter back to the assessing officer to redo the assessment afresh. The appellant is not aggrieved by such portion of the order, but is aggrieved by the direction issued by the learned tribunal in imposing a cost of rupees 50,000 on the SSC payable to the legal aid services. Before the learned tribunal, the SSC contended that he is a small trader of glass articles, an individual SSC who was solely dependent upon the consultant/accountant, and due to ill health and poor knowledge regarding online compliances, the SSC was unaware that the consultant did not comply with the notices issued by the assessing officer on 2 occasions, which led to the assessment being completed ex parte by order dated 23/10/2019 under section 143 within bracket 3 of the Act. The SSC carried the matter on appeal. Though the appeal was presented, the consultant of the appellant did not appear on 3 occasions. Therefore, the appellate authority proceeded to dispose of the appeal. We have perused the order passed by the appellate authority dated 11/10/2023, and we find that the appellate authority has not dealt with the grounds which have been canvassed by the appellant in the appeal petition, but has stated that no interference is called for with the order passed by the assessing officer. The learned tribe, when the matter was carried to the learned tribunal, the tribe, the reasons pleaded by the assessee for non-appearance before the assessing officer and before the appellate authority was not being disputed by the revenue. In other words, there was no material to state, no material placed before the tribunal by the revenue to show that the stand taken by the assessee for his non-appearance was for reasons beyond his control, and there is nothing, the assessee had made any false statement. In any event, when the assessee had filed the statutory appeal within the period of limitation, it is not a case where the assessee was not diligent of his rights. But being an individual in all probabilities, was not well versed with the procedures and was solely dependent upon the consultant, who appears to have not taken steps to comply with the notices issued by the assessing officer or by the appellate authority. In any event, the learned tribunal opined that the assessment has to be redone and remanded the matter back to the assessing officer. However, we find that imposition of cost of rupees 50,000 would be harsh on the appellant, more particularly when he is a small-time trader and an individual assessee. That apart, the issue pertains to the assessment year 2017-18. Therefore, the assessee has undertaken before this court that he will cooperate in the assessment proceedings, in the de novo assessment proceedings, in terms of the directions issued by the learned tribunal, and one more opportunity may be granted. Considering the above, this appeal is allowed, and the cost imposed by the learned tribunal on the appellant assessee is set aside, and the matter stands remanded to the assessing officer for a fresh decision. The assessing officer shall issue notice to the appellant assessee, and he shall comply with the notice by appearing in person or through the authorized representative without seeking for any adjournment, and place all materials that may be called for by the assessing officer. And upon considering such materials as well as the submissions the assessee may make, a fresh assessment order be passed on merits and in accordance with law. Consequently, the substantial questions of law are left open.
If your lordship kindly will frame a time, because we not assessment year 17-18 will not done the
We
assessee.
don't know his pressure now. Couldn't come.
I have your lordship's kind leave to file an intra-court appeal without the certified copy.
Date of the order?
September 3, 2025. We've applied for the certified copy on September 4.
All right, leave granted.
Appellate side, daily list, serial number 1.
Department's appeal
Perhaps
must be against Justice Nizamuddin's order. Whether the approval is obtained from the appropriate authority, he would have remanded the matter long back. Correct? Yeah. With liberty to pass freshes with correct PAN number. What are your grounds? The waste of time, sir. Oh. Who appeared for the assessee? He's no more. We have heard Mr. Soman Bhattacharya. learned advocate appearing for the appellant department. Though the respondent has been served, none appears for the respondent. The appearance of the learned standing, Mr. Soman Bhattacharya, learned standing counsel for the appellant department be regularized and his fee bills be honored. This intra-court appeal is directed against an order which was order dated 15th November 2021, passed in WPA 14526 of 2021. By the said order, the assessment order was set aside. Assessment order and the consequential demand were set aside, and liberty was granted to the assessing officer to pass fresh assessment order with the correct PAN number, which appears in page number 105, being annexure P16 to the writ petition. In paragraph 2 of the impugned order, the learned single bench has recorded that the department could not contradict the mistake committed by them by quoting the wrong PAN number, which are matters of record. In the grounds of appeal, the appellant department would contend that the impugned order is not sustainable, more particularly when the assessing officer has no jurisdiction to pass fresh assessment order against PAN hyphen capital A, capital P, capital C, capital S, 6166, capital F. It is there in page 4, ground number 4, which falls within the jurisdiction of the income tax officer, Ward 1 within bracket 1, Dibrugarh. And the assessee has been holding two different PANs at the same time. These facts appear to have not been placed before the learned single bench when the writ petition was disposed of. Needless to state that if there is a mistake in the PAN number and the jurisdictional assessing officer who is in charge of the correct PAN number has to pass fresh orders. Accordingly, we clarify this position and dispose of the appeal filed by the department with the direction to the concerned jurisdictional assessing officer to pass fresh orders of assessment after notice and hearing the respondent assessee.
Real number 2.
Where is Mr. Bhaskar Sengupta?
Mr. Tanay Chakraborty is not in Calcutta. I have been told. Mr. Tanay. It's a state's appeal, I think. So he's not in Calcutta.
Dismiss it.
The clerk told me to just mention 2, 3.
He's already gone on vacation, is it?
No, he's for some private matter at Delhi.
Delhi. Mr. Javed Ahmad Khan, Bhaskar Sengupta, he Ahmad Khan appeared. It is submitted that the learned counsel appearing for the appellant state is not available. Urgent.
Real number 3.
I am for the respondent.
3 also same order. Tana is not there.
Real number 4
I may appear for.
and 5.
Yes.
What is this?
But imposition of penalty for expiry of the e-way bill.
How many hours? How
If,
many
my lord,
days?
if it is considered, my lord, 8 hours for extension of the way bills, my lord, validity, then my lord, it's 17 hours. Otherwise, it's 25 hours.
And what was your explanation?
My lord, I have explained, my lord, because of the, my lord, traffic snarl on the highway, my lord, the driver could not reach, my lord, the place within the scheduled time, my lord. Therefore, the e-waybill expired and he, my lord, carried
Where is the appellate authority's order?
My lord, your lordship just again. Appellate authority's order is at page, your lordship will find page number 63 to 72. My lord. I am covered by your lordship's decision, my lord.
Otherwise, there is no discrepancy.
Nothing, my lord, nothing. He discussed the judgment, my lord, passed by your lordship in the Ashok Sureka's case. He said in that case, my lord, there was a delay of 17 hours. In your case, more than 24 hours. That is 24 hours. Therefore, my lord,
No. The validity of the e-waybill as produced by the driver expired on the midnight of 27/7/2022.
Yes.
But the validity period of the bill not extended, although sufficient time was available, because the vehicle was intercepted on 1:15 a.m. on 29/7. That
Yes,
is after a lapse
25
of
hours.
25 hours.
But if it is 8 hours is deducted, my lord, which is allowed for, my lord, getting the waybill extended, then it's 17 hours. Well, kindly see, honorable, your lordship has relied upon the Supreme Court judgment, my lord. If there is no evasion of tax, my lord, no penalty should be imposed, my lord. Judgment. Satyam Sivam. No other allegation, my lord. The adjudication authority's order is that your lordship will find page 35 to 37, my lord. Page 37, paragraph 7, my lord.
1 second. In the report GST MOV 04, except e-waybill, there is no other allegation.
Nothing, my lord, nothing. My lord, kindly see the order itself, my lord, page 35.
1 second.
There was no discrepancy with regard to quantity, quality, value, or, my lord, there is no allegation that the goods were found in different location, my lord.
But then he issued show cause notice on 11/8/2022.
Yes.
But the order was passed on 4/8/2022.
Because, my lord, I appeared before the authority. I said that I am paying the penalty amount for getting the goods released. He considered it is my submission that I have not made any submission, my lord. Kindly consider, my lord, page 33.
So you wanted the goods to be released, therefore you agreed to pay.
Yes, my lord. Page 37, sorry, my lord. Page 37. It's the part of the order, my lord. GST MOV 9. Paragraph 7, my lord. Last paragraph. Mr. Sajal Kumar Mitra, authorized representative of the owner of the goods, appears on 4th August 2022 and filed a petition. My lord, this is the date of so cause notice. Filed a petition for early hearing instead of the date fixed for personal hearing on such and such. As per his request, the case is taken up for personal hearing today. He has no explanation as to why the conveyance is moving with taxable goods without valid e-waybill.
But you have not paid it under protest.
My lord, under the, my lord, GST portal, there is no scope to, my lord, declare as to why I am paying so, my lord. And, my lord, in the appeal, my lord, I have stated specifically, my lord, paragraph 6, my lord, page 50, statement of facts, my lord, paragraph 6, my lord. page 50. And my lord, my destination was only 4 hours from the, my lord, the place where the goods were detained, my lord, or intercepted, my lord. And it was on the same route, my lord.
All right, show the show cause notice.
The show cause notice, my lord, your lordship will find page number 30. 32. Paragraph 2, my lord. This is the reason for which the notice was issued, my lord. The driver of the conveyance has produced an invoice bearing number such and such and an expired e-way bill bearing number such and such relating to the goods under transportation at the time of interception of the conveyance. No valid e-way bill has been tendered for the goods in movement.
But though this show cause was issued on 4th
Yes.
August, you filed an advance hearing before him and you paid the money.
I paid the money and produced a challan for getting the goods released, my lord, because it's a biri leaves, my lord, tobacco leaves, my lord. Well, there is a chance, my lord, of getting the moisture, my lord, absorbed. So we got it, the goods released. We have paid the forest fee.
What happened to your writ petition?
Well, writ petition is pending, my lord. And my lord, within 20, my lord, in case of 24 hours, my lord, the writ court is consistently, my lord, passing the order.
Anybody else for the state is here? What is this?
Setting aside the, my lord.
No, state.
Recently, my lord, this the learned single judge has passed the order, my lord, on the single practice where the VE will expired within, my lord, for less than 17 hours. Penalty order was quashed, relying upon your lordship's decision.
And how much was the penalty?
2 lakh and on, my lord. Two lakh 9,000, my lord. Each. Total 4 lakhs.
Along with Tanay Chakravarti, one is the personal notice. Yes.
So he has been served.
Ask it, sir. आपके मास्क के?
He's on his way, my lord, to court.
So he is here, na?
Yes.
This intra-court appeal by the writ petitioner is directed against the order passed by the learned single bench dated 8/4/2024 in WPA 8453 of 2024, holding that there is no scope for passing any interim order and the matter requires affidavits to be filed for final adjudication. Accordingly, directions were issued for filing affidavits. The appellant has filed this intra-court appeal contending that the scope of the writ petition is very narrow, and there are several decisions of this court there are decisions of the Honorable Supreme Court and this court wherein similar orders orders imposing penalty under section 129 of the CGST/WBGST Act were put to challenge and they were set aside, as the only ground was that the VA bill had expired. Therefore, it is submitted that the writ petition and the appeal may be disposed of. We have heard the submissions of the learned advocate for the respondent. We have heard the learned advocate for the respondent on the above submission. With the consent of the learned advocates on either side, the writ petition as well as this appeal are disposed of by this common judgment and order. Sir, in the cost statement, you have to show appeal number and writ number. and call for the writ from the department. Otherwise, in the CAS, that will be shown as pending. In fact, I corrected 2 orders. Yesterday, you have sent it. Today, I signed. The appellant had filed the writ petition challenging the order passed by the Senior Joint Commissioner State Tax, Berhampur Circle, namely the appellate authority, dated 1/9/2023, by which the appeal filed by the assessee, by the appellant, challenging the order
It's 37.
passed by the Assistant Commissioner of Revenue, Krishna Nagar Charge, West Bengal, under section 129 within bracket 1, 129 within bracket 3, read with section 68 within bracket 3 of the WB GST Act 2017 and read with the relevant provisions of the CGST Act 2017, IGST Act 2017 and Goods and Services within bracket compensation to states bracket close Act 2017 and the rules made thereunder. The assessee is a partnership firm engaged in the trading business of BD leaves within bracket Tendu leaves, Kendu, AENDU. They had placed an order with Messrs. Sakti Swarup Enterprises at Chhattisgarh, and the supplier had supplied 329 bags of the said leaves and raised invoice number 03-22-23 dated 21/7/2022 on the appellant, and the goods were loaded in a vehicle bearing registration number CG004HC 9111, and the goods were to be delivered to the appellant at Krishna Nagar, West Bengal. The vendor generated e-way bill number 841 space 4104 space 1229, which was valid up to 27/7/2022. The vehicle was intercepted by the authority on 29/7/2022 at about 1:05 a.m. Noting that the e-way bill had expired in the midnight of 27/7/2022, the goods were sought to be confiscated. Show cause notice was issued, and the appellant appeared before the authority and contended that since the goods were perishable, without prejudice to their rights and contentions, they had paid the penalty and the goods may be released. After the goods were released, appeal was preferred. In the appeal, before the appellate authority, various grounds have been raised, and reliance was also placed on the various decisions of the courts. Which have held
Page 53, Mali.
that when goods could not be delivered within validity period of e-way bill because of traffic blockage, and while detaining the goods, the GST officer kept the same in his house of his relative instead of designated place, additional cost was imposed on the authority in view of the harassment faced by the assessee. In this regard, reliance was placed on the decision of the Honorable Supreme Court in Assistant Commissioner within bracket ST versus Satyam Shivam Papers Private Limited, 2022-134 taxman.com 241 within bracket SC. Have you got any our decision?
Yes.
Full stop. In the instant case, admittedly, there is no other dispute or discrepancy raised by the department. Udayan,
Judgment of the
by the department, except to state that the VEA bill had expired. Under the statute, the transporter or the owner of the goods or the supplier can extend the EVA bill within a period of 8 hours. If the said 8 hours is time is given to the appellant, then the delay would be 17 hours. The petitioner would state, the appellant would state that the delay occurred on account of traffic blockage, which fact has not been disputed by the department, nor there is any record to dispute the said plea raised by the appellant. That apart, there is nothing to indicate that there was an intention on the part of the appellant to evade payment of tax. And in such circumstances, imposition of penalty at the rate of 200%, that too in a mechanical manner, is not justified. Our view is supported by the decision of the division bench in the case of Progressive Metal Private Limited versus Deputy Commissioner, State Tax, Bureau of Investigation, South Bengal, Durgapur Zone, MAT 562 of 2025 dated 28/4/2022. Furthermore, what was the distance between the place of
4 hours?
201
kilometers.
200 kilometers. Furthermore, the distance between the place where the goods were, where the vehicle was intercepted, and the place where the goods were to be delivered was about 200 kilometers to be covered within less than 4 hours. Thus, considering the undisputed facts and the only allegation being that the EVA bill was not extended, we are of the view that it is not a case where 200% penalty should have been imposed on the appellant.
Paragraph 5 onwards, my lord.
Pardon?
In your lordship decision, paragraph 5 onwards. My lord, we need to go into the various judgments which were referred by the learned advocate for the appellant and the learned advocate for the state.
In Progressive Metal Private Limited, more or less similar facts were considered by the court, and the court and after taking note of Rule 138 of the WBGST rules, which allows the transporter 8 hours time to seek for extension, and if such allowance was granted, in the said case, the delay was about 1 hour and 35 minutes. Though in the case on hand, the delays, the delay after giving the 8 hours allowance, is 17 hours, the revenue has not been able to demonstrate lack of bona fides on the part of the appellant. Therefore, we are of the clear view that the case on hand is not one such case where 200% penalty could have been imposed. Accordingly, the appeal and the writ petition are allowed, and the orders passed by the appellate authority and the original authority are set aside, and the department is directed to, and the appropriate authority of the department is directed to refund the penalty recovered from the appellant upon an application being filed by the appellant within 8 weeks from the date of filing such application. Five is also
same, my lord, same facts. On the same day, two vehicles consecutive.
But then
the amount of penalties, my lord.
Shall I get the vehicle number? You, sir, give the second one. If you go to the appellate authority's order, the statement of facts it will be there. The number of bags also same?
No,
Ah. Actually, we should be correct, sir.
329 bags. my lord. Same.
Same only. Hmm. 865. Hmm. 329 same. Invoice also 21/7. Vehicle number is CG04 DM 2800. Same validity also does. Separate hours. And you mark the appearance of the club.
Serial number 6.
What is 6?
My lord, 6 probably it has been disposed of, my lord, on 18th October 2024.
Ah.
1994.
No. Some cost was imposed.
Oh my lord. Post
This is by the vacation code.
vacation code, my lord.
Calcutta High Court Legal Services Committee is reduced to 25,000 to 15,000.
Yes.
Then Supreme Court, what did they do? We grant further time of 1 week to petitioner to file an appeal. What appeal? No.
That is where appealable were, therefore, my lord, division was granted liberty, my lord.
So nothing more is required.
Nothing.
The present appeal was disposed of by order dated 18/10/2024 by extending the time stipulated by the learned single bench for approaching the appellate authority and directing the appellant to pay a sum of rupees 15,000 to the Calcutta High Court Legal Services Committee. The appellant filed a special leave petition before the Honorable Supreme Court. For this they went. In special leave to appeal C number 25757 of 2024, which was dismissed by order dated 5/11/2024. The Honorable Supreme Court had extended the time for compliance of the direction of the division bench by further period of 1 week to enable the appellant to file the statutory appeal. None appears for the appellant, and therefore we are not aware as to whether the amount was paid and whether the appeal was preferred before the appellate authority. In such circumstances, no further orders are required, and the appeal stands disposed of in terms of the earlier order, which has merged with the order passed by the Honorable Supreme.
Grateful.
Next.
Serial number 7.
In this matter, Mr. Pitu Dudure is appearing. Lord,
Where is he? This is also approval matter.
this is not approval matter without we have some submission because this approval relate to judgment of Ashish Agarwal. Initially, 140 notice.
All right, then you serve notice.
No, there is a delay of 525 days, Your Lordship.
We have heard Mr. Prithu Dorial and an advocate appearing for the appellant department, and Mr. Saurav Bagaria along with Mr. Wrights Goel appearing for the respondent SSC. This appeal is filed by the department challenging the order passed by the learned single bench dated 28/4/2023 in WPA 5755 of 2023. There is a delay of
524 days.
524 days in filing the appeal. We have perused the affidavit filed in support of such application and we find that no acceptable reasons have been given for the inordinate delay, except to state that the file kept moving from one officer to another. That apart, in the impugned order, the learned single bench has not foreclosed the rights of the department and has granted liberty to the income tax authorities to initiate fresh proceedings in accordance with the law. Therefore, we fail to understand as to why the department was aggrieved by such an order. In any event, if the department was aggrieved, the appeal should have been filed within the period of limitation. But whereas in the instant case, there is a delay of 524 days in filing the appeal. In the absence of any acceptable explanation, we are not persuaded to exercise any discretion in favor of the appellant department. Accordingly, the application in GA number so and so, CAN number so and so stands dismissed. Consequently, the appeal stands rejected. The liberty granted by the learned single bench stands preserved.
But we have filed an affidavit of service kept. Affidavit of service kept in record.
Affidavit of service kept on record. Next.
Material number 8. I apologize for today.
We set aside 2 lakhs penalty.
Yeah, that I know, but 25 hours, your lordship.
25 hours, less than 8 hours, 17 hours, no discrepancy, 2 trucks. There was traffic jam.
That was the appellate authority said.
Heavy traffic, sir. Throughout the week, if you travel anywhere.
Lordship, that's what the difference. That's why it was difficult for me to come. I had personal difficulty.
But when we were moving also on Saturday from Durgapur to here, up to Hooghly, road was not too good, but heavy vehicle traffic. Of course, they had this pilot and other things. In spite of that, then once you crossed, nearing Hooghly,
Danpuri, that place.
Kilometers
But truck congestion has been due to the
some days. In fact, last year we went to Hooghly Motion. You couldn't reach. Last year we went to Hooghly Motion College. Ladyship was then Registrar General. She couldn't reach.
It's very nice.
And the Vice Chancellor NUJS reached at 2 p.m. By then function everything over.
My lord, in this matter, the petitioner has opted to settle the dispute under the Settlement of Dispute Act, and accordingly, they have filed an application in Form 1 and they have paid the appropriate tax. And
what happened to the application? That is processed.
No, Form 3 has been issued, and the matter is pending only for the order of leave from this. Order of leave from this court. Yes, we have already filed a leave application before this honorable court, but that has been filed.
No, which is the matter you are?
Item number 8, WPTT 12.
Yes. You show where is your application? So now form number 1 you submitted.
Yes, my lord.
And what did the department do?
My lord, they have issued form number 3.
Page
24, my lord. At the bottom, you are requested to furnish within 2 months.
Okay. This appeal has been filed by the SSC. No, sorry. This writ petition has been filed by the SSC challenging the order passed by the West Bengal Taxation Tribunal Tribunal dated 9/12/2024 by which the application filed by the appellant SSC being RN-216 of 2024 was dismissed. After the order was passed by the tribunal, what is the date on which you filed Form 1?
It's 16. My lord, 14th August 2025. Page 16.
No. No. After the appellant had filed this writ petition on 23rd May 2025. When the writ petition was pending, the appellant thought fit to resolve the issue by approaching the authorities under the provisions of the West Bengal sales tax within bracket settlement of dispute bracket close rules 1999, and accordingly an application was filed in Form 1 on 18/4/2025. The disputed tax, the admitted tax, has also been remitted, for which e-challan has been issued in favor of the appellant. The application in Form number 1 was processed by the authority, namely the Joint Commissioner, Commercial Taxes, Large Taxpayers Unit, and Form number 3 has been issued, in which a discrepancy has been noted, stating that the appellant should furnish within 2 months from the date of application evidence that they have sought leave from this court for applying for settlement of the dispute. Since the application in Form 1 was filed during the pendency of the writ petition, the authority is entitled to entertain the application, and leave is granted to the appellant to process the application and once and for all settle the dispute with regard to the said tax liability. With the above observation, the writ petition stands disposed of. Next.
Serial number 9.
My lord, appellant is thinking about availing the benefit of SOT scheme pronounced by West Bengal Legislative Assembly. So kindly let the matter go out of the list, my lord.
We will grant you liberty.
No, still it has time up to 30th September.
No.
There are certain technical hitch, my lord, as because, my lord, there is an FIR lodged against the petitioner, my lord. Until it is compounded, my lord, it is in process, my lord. Until it is compounded, I cannot avail the SOT.
It is submitted by the learned advocate. It is submitted by the learned advocate for the petitioner that the petitioner is desirous of approaching the authorities for settlement of the dispute, and the matter is under progress, and request for adjournment of the writ petition. Let the matter appear on
application,
on the 11th November.
My lord,
in the admission list.
Serial number 10.
Murshidabad.
So Lordship is already elaborately heard, my lord. So Lordship, detailed order has been filed. Now he has to respond on section 74.
He is engaged before court number 42. But my lord, Your Lordship, going to the merit of the matter, my lord, I don't think we have much more to say in the matter.
In fact, it will be better.
Learned friend is the answering response.
Better if we hear AG. In the long run, it will help you.
But it is
My lord can
decided on section 74.
Possibly I decide. I should shirk my responsibility.
But kindly consider, my lord, on merit.
Thursday. List on Thursday. As it is submitted that the learned advocate general is not available today. Next.
Serial number 11.
Union of India. 11.
Serial number 11.
My lord, I am appearing.
My lord, I have been instructed that Mr. Kundulia is appearing this matter. My lord. He is on his legs.
My lord, I am only seeking a remand in this matter. Very short issue, my lord. Kindly hear me for 2 minutes, my lord. But I'll just, my lord, without looking into the brief, my lord, kindly hear me. My lord, what has happened is that a audit took place in my premises, Thereafter, my lord, they looked at my balance sheet for 5 years. Whatever was there in my sundry creditors, they presume that all of it, my lord, second proviso to section 16 says that if I don't make payment to the sundry creditor within 180 days, then, my lord, I am mandated to reverse my ITC. Here, my lord, on the analysis, my lord, just looking at the closing figure in the balance sheet, that this is my outstanding in the sundry creditors. For 5 years balance sheet, he just looks at it. 5 officers come to my premises for audit. They don't examine anything. And they say that all of it, payment is beyond 180 days. So I am required. So he presumes that all the purchases are at the rate of 28%. He does not dispute that I'm in the business of manufacture of industrial safety garment. Now, only there are very limited items in 28% bracket. There are cars, tobacco, sin goods. So he presumes that all of it is 28% and all of it is beyond 180 days. Now, in response to audit observation, I furnish a detailed ledger of all the parties. I furnish a statement that this is the period of outstanding. In some case, maybe it is 90 days, 20 days, 140 days, but only except for 2,000 or 4,000 outstanding. All of it is within 140 days. Now he ignores my reply to the audit observation. He issues a so-called notice without even looking at my reply, on the same ground that all of it is beyond 180 days. Again, my lord, I furnish the detailed statement and everything. So in the order, my lord, he says that you have not furnished the bank statement. So even though it appears, in the order he records that it appears that all the payment is within 180 days, but since you have not furnished the bank statement, so your claim is rejected, my lord. There was a audit.
You could have produced the bank statement.
My lord, had he demanded me, my lord, in the course of audit observation, 5 officers come to my premises, they don't demand bank statement. Audit observation they give, they don't demand bank statement. So-called notice they give, they don't demand bank statement. Now in the order he is saying that you have not produced bank statement. So even though all the payment appears to be within 180 days, my lord, it is not believable. So I am willing to furnish the bank statement if the officer so demands it. Let it be remanded back. And the other issue, my lord, is that, my lord, some credits are appearing in my 2A, which I have not taken, my lord. Maybe because 2A, how it auto-populates that my lord, anybody who gives my TIN number, it will appear in my 2A. So there are some, my lord, people who have mistakenly given my number. I have not even availed those credit. I give a detailed 2A statement against this demand, and I say that I have not availed this credit. Please have a look at it. He said that you have not furnished documentary evidence, so my credit is comfort. Now, my lord, something which I have not availed, I can only make any statement because something which I have not even purchased. How?
If you have not availed, you make a statement. They can verify from.
They can verify from 2A whether that invoice is pertaining to me. They have the.
Then before the appellate authority, you could have placed all.
My lord, kindly consider, my lord, there is a demand of around, say, my lord, 2 crore rupees. It is a small enterprise.
Have you filed an appeal?
My lord?
Did you file an appeal?
No, we did not file an appeal, my lord. I am seeking a remand back, my lord, because this is a question of determination of the jurisdictional fact, my lord. The fact has to be determined whether, my lord, at all I am, my lord, this 28%, my lord, it is absolutely arbitrary and, my lord, unreasonable. My lord.
Where is the adjudication order?
My lord, kindly have a look at.
We don't have the stay petition.
My lord, it is there, my lord. We have filed it.
No stay petition is there. You have got stay petition?
Yes, I have.
Lord, I am giving. It is there, my lord, in the file. We have filed.
MAT 1196.
With other file.
Okay.
Yes. It is the one. Only one. Very good.
My lord,
This is volume 1. There are 5 volumes.
5 volumes.
Yes.
Because number of documents we furnished in response to reply and audit observation. That is why, my lord, it has become bulky.
Wait.
All the documents.
We are searching.
Hey, there.
See, you should make a convenience set. You dump all these
No, my lord,
things.
whatever documents.
What is required to be seen is the order of adjudication. That is first the show cause notice issued by the inspecting officers, your reply, then the show cause notice by the officer, your reply, adjudication.
So with reply, my lord, I annexed all the ledgers and documents.
Why we are not here to
No, my lord,
examine.
I understand, my lord, but
your case itself, it matter has to go back.
my lord,
You
I
have to
understand
convince
that.
us saying that this
No,
was
no, I am not asking your lordship to look into document, but my lord, if I don't.
how to handle this, I'm saying. You have to stop this at some point of time, sir.
But
Unnecessary, you make the issue bulky.
But if we don't enclose the documentary evidence, then my lord,
correct, sir.
May
You
say
do it for a regular filing, you do. Apart from that, what are the essential minus the annexures? You could have. Where is the adjudication?
But the adjudication order is on
which volume first?
Page. We had filed a supplementary affidavit, my lord, because there was some.
No, you do one thing.
It is there, my lord.
You prepare a convenience. We find there are 5 volumes in the stay application, with most of which are.
No, it is part of that only, my lord.
Most of which are annexures to the reply given by the appellant to the show cause notice.
My lord, kindly
Since
look.
the papers are bulky, difficult to handle, the learned advocate appearing for the appellant is requested to make a convenience set containing the following documents. Number 1, show cause notice issued by disturbancy notice.
Well, kindly have a look at 994. Kindly for
the disturbancy notice issued by the inspecting officers, reply given by the appellant assessee, show cause notice, reply given to the show cause notice, and the order of adjudication. The annexures to the replies and the annexures to the adjudication orders need not be included in the convenience set. List on Thursday.
Great.
Serial number 12.
What is serial number 12?
My lord, before the learned single judge, we were on the issue that where an order was passed without affording any opportunity of hearing, such order could not have been sustained. And my lord accordingly prayed for quashing of such orders and adjudication of it. But my lord, the learned single judge had relegated us to appeal, citing alternative remedy. Now, my lord, it is good law that when an order has been passed in violation of the principles of natural justice, there would not be any bar on invoking the writ jurisdiction.
Correct.
My lord, my only prayer is that the matter may be remanded to the first authority.
When was the adjudication order passed?
Lord, it was passed on 23rd of April 2024.
April 20. Sir, April it was passed, July he has come here. There is no delay and all. Where is the order of adjudication? Adjudication order, your
My lord, kindly turns to page 125, my lord.
$125.
My lord, in fact, it is copy pasted from the audit report. No application of mind has been done in this order.
Disturbancy notice was issued. Then what happened?
My lord, then show cause was issued. We replied.
Where is that?
My lord, show cause notice, my lord, kindly turns to page 85. Look, kindly has the last page of the show cause notice, page 101. He's simply asking me to make payment.
No, this is a show. This is page 86. This is a discrepancy notice.
My lord, he has copy pasted the discrepancy notice all along. He has not issued fresh. He has just simply changed the headings.
Oh, page 85. He says it's a show cause under 73(1), but cut copy paste of the discrepancy. And he says pay. No opportunity.
No opportunity.
Then you have not paid. Then he issues a demand.
He issues a demand.
Page.
We file a petition before.
Page.
Actually, but they have filed a reply. As per my instruction, they have filed a reply against the show cause notice.
No. Discrepancy notice he has filed. Discrepancy notice he has filed. In the show cause, what you should do is deal with the discrepancy notice, his submission. Then the officer should come to a conclusion that this submission to the discrepancy notice is not acceptable. Therefore, show cause why demand.
That should have been done.
No, it has not been done.
That should.
Page, where is the adjudication order?
My lord, adjudication order appears at page 119.
No, there will be an annexure speaking order.
Where is that page 125?
Page 124. So one discrepancy is reconciled. Page 126, he says, discrepancy 1 is reconciled. Then discrepancy 2, 126. First discrepancy, you see the last paragraph. Second is claim of input tax, excess claim. But page 129, you have accepted the discrepancy.
Yes, my lord, certain discrepancies I have accepted.
All right. Which is the discrepancy which you are disputing?
My lord, discrepancy 3.
But he would have given you a personal hearing, no?
No, we replied, but he has not afforded any opportunity of hearing.
That is mandatory, no?
My lord, section 75(4).
Please give that section. The appellant filed the writ petition in WPA 193/89 of 2024, challenging an order passed under section 75 within bracket 4 of the WBGST/CGST Act 2017 within bracket referred to as the said act, dated 23rd April 2024. The learned single bench was of the view that the appellant should avail the alternate remedy and granted time to file the statutory appeal. Agreed by such direction, the appellant has preferred the present appeal, intra-court appeal. We have heard so much. We have carefully examined the annexures to the stay application, and we find that at the first instance, certain discrepancies were alleged against the appellant assessee, and a notice communicating the discrepancies was issued on 25/7/2023. It is admitted by the department that the assessee had furnished the relevant details, and the authorized representative also appeared before the concerned officer on several dates. Therefore, the next step would be either to accept the explanation offered by the assessee to the discrepancies or to proceed further to issue the show cause notice under section 73 within bracket 1 of the Act. What is required to be done by the authority is, no, please take out. In the event the authority is not satisfied with the explanation offered to the discrepancies, such explanation should be dealt with in the show cause notice, and a prima facie view has to be recorded as to why the assessee is liable to reverse the ITC or liable to pay taxes or penalty or interest, etc. In the instant case, we find from the show cause notice issued under section 73 within bracket 1 of the Act as contained in annexure P3, what the authority has done is he has extracted the contents of the discrepancy notice, and some of which are said to have been reconciled and accepted. However, in respect of certain discrepancies, the authority has not accepted the explanation of the assessee, which has led to an order being passed directing reversal of the alleged excess ITC. This statute, namely subsection 6 of section
4, my lord.
4 of
Section
75 mandates a personal hearing to be granted to the assessee. This has not been done, and therefore the matter requires to be remanded back to the adjudicating authority for a fresh decision. Since certain discrepancies which have been explained by the assessee have been accepted by the department, it would be in the interest of the department as well as the assessee to issue a fresh show cause notice, pointing out only such are the discrepancies which are not accepted by the department, and the appellant shall be granted an opportunity to submit their reply within 3 weeks from the date on which the fresh show cause notice is issued. Thereafter, the appropriate authority shall afford an opportunity of personal hearing to the authorized representative of the appellant and redo the assessment and pass fresh orders on merits and in accordance with it. With the above direction, the appeal stands disposed.
My lord, there is a delay of about 10 months, my lord, semi-controlled.
In filing the appeal, 10 months.
10 months.
Then we would have dismissed them. All right. First paragraph, they say there is a delay of 290 days in filing the appeal. We have perused. So we have perused the affidavit filed in support of the application, and we find that the reasons given by the appellant, who is the sole proprietor of a proprietorship, is acceptable. Accordingly, delay is condoned. Can 1 of 2025 is allowed.
Deeply obliged, my lord.
You are grateful, my lord.
Lordship, I am being led by Mr. Chatterjee.
Thank you.
Grateful.
So this is a matter of seizure under section 129, my lord. My lord, the goods were moving from Assam, my lord, for certain job work, my lord. From two different dealers, but my lord, related dealers, my lord. One having place of business in Assam 1 and pin code number 1, and another having business at pin code number 5, my lord. They're separate entities, my lord.
Both in Assam.
Both in Assam, in Guwahati. Now, the goods were coming, my lord, to West Bengal for certain job work, my lord. Lordship comes down to, my lord, page number 59 is the invoice, my lord. My lord, from the top, my lord, on the right hand side, my lord, place of supply, my lord.
West Bengal.
Yes, my lord, it ought to have been Assam.
Where in West Bengal?
My lord, it is coming from Assam, my lord. It ought to have been Assam, my lord. Not West Bengal. Well, second, my lord, there are two anomalies.
Suppose somebody asks somebody in abroad, where are you going? I'm going to India.
Well, the
India has
consignment
got
note,
how many states?
but consignment note as well as the e-way bill will be speaking, my lord. Well, thereafter, my lord, in West Bengal, my lord, the name is Mahabir Dealers, my lord, address is Bastalla, my lord, Barabajar, Kolkata 7. It is given, my lord. Where in West Bengal, my lord?
Page 60.
My lord, see 59, my lord. 59.
Where the address is given?
My lord, Mahabir Dais, my lord.
Mahavir Days.
Thereafter, my lord, 31 by oblique B, Adi Bastalla, Lane, Barabazar, Kolkata 7, my lord. This is the place. Thereafter, my lord, below, my lord, the description of the goods, my lord, it is clearly written that the above said goods are being sent for remaking, my lord. My lord. Herein after, my lord, I'm coming to the SOCOS notice, my lord. It cannot be improved subsequently, my lord. What are the allegation in the SOCOS notice, my lord? Page number 84. My lord, if lordship sees, my lord, paragraph number 2, my lord. 2I, my lord. I is the other seizure goods, my lord. And II, my lord. Below that, my lord, II delivery challan number MCJ/058, my lord. 2II. My lord. This is the goods in question in this writ, my lord. Delivery challan number MCJ/058 dated 7/11/23 accompanied shipping note number this is found to identify the consignor Manikchand Jewellers and Sons Jewellers Private Limited. Consignee is Mahavir Dais, GST number this. Item is gold, 24 carats, my lord. The weight is 1000 grams, value approx 61 lakhs, and place of supply is West Bengal. And specifically recorded the following under remarks: the said goods are being sent for remaking. Thereafter, my lord, the next page, my lord. 85, my lord. From the middle, my lord, the following discrepancies are observed, my lord. Lord, you got it, my lord. 85. Following, my lord, thereafter, my lord, 1 and 2 is for the other goods, my lord. 3 is in respect of this goods, my lord. Delivery challan MCJ/058 dated this is also found without any mention of job work or identification of finished items at all. In delivery challan number MCJ/058 dated this, other than recording the above said goods are being sent for remaking, the goods being identified as gold 24 carat, the term making cannot associate with the term and is hence unacceptable, my lord. They say it is not coming for job work. This is only allegation upon me.
No. Allegation is fabrication.
My lord?
Allegation is fabrication. Fabrication of that booking date and whatever courier slip. All right. Show cause was issued. You gave reply. Then what happened to the authority?
My lord.
Page 97 is the adjudication order, your lordship.
97, my lord.
97 and in 98, whatever your lordship has said, it has been covered in 98.
My lord, I'm coming, my lord. 98, my lord.
You filed appeal, sir.
My lord?
Mr. Arora, you file appeal.
No, I'm coming from the appeal, my lord.
Oh, you.
My lord, only on this point, my lord, it is coming for job work. No way bill is applicable, my lord. In the returns, it is.
Unfortunately, the authority did not see the country of origin.
My lord?
Whether any foreign marking was there or
Well, this is not has not been.
It is gold bar and gold coins.
Well, gold bar.
Gold bar.
24 carats, my lord.
Gold bar cannot come for remaking. Old jewelry can come for remaking, and it is coming from somewhere else.
And
My lord?
Page 98.
Now,
my lord, it has not been questioned that it is coming from somewhere else, my lord.
All right. Now, what did the learned single bench do?
Well, single bench, my lord, exchange of affidavit, my lord.
Exchange because
Affidavit.
factually it
Rightly
is
so.
required. Factually, it is absolutely required. Your lordship.
We'll probably advance the time.
Well, in fact, my lord, lordship comes, my lord.
Now the goods have already been released. So let him make the remaking and send it back to Assam.
It has already been sent, my lord.
Then,
it has already gone.
Then you produce that also in your supplementary affidavit, saying that it's a genuine remaking. Goods have been sent back to Assam. That delivery challan, etc., invoice, whatever you have raised, you can produce.
Well, let a time frame be fixed, my lord. Otherwise, my lord, I had given a bank guarantee which after passing the appellate order, my lord, within 1 month, my lord, it was encashed, my lord. It is a huge amount of money, my lord, involved. It was valid till December.
But what they can do within 8-10 days, puja is approaching.
After puja is your lordship. What's the
6
timeline?
weeks has been given on what date? 4th of August. By now you should have filed.
There has been. After puja, any day after puja, if your lordship.
This is an intra-court appeal challenging an order passed by the learned single bench, directing affidavit in opposition to be filed within a time frame and reply also. After hearing the learned advocates for the parties and carefully going through the materials placed on record, we find that in order to adjudicate the correctness of the impugned orders in the writ petition, affidavits are required to be filed. And the learned single bench was right in directing affidavit in opposition to be filed by the department and also giving liberty to the appellant writ petitioner to file their reply. The learned advocate appearing for the appellant submitted that soon after the appellate authority dismissed the appeal petition, the bank guarantee furnished by the appellant has been encashed. Further, it is submitted that the gold which was brought from Assam to West Bengal for remaking has been complied with and the goods have been sent back. In order to adjudicate the correctness of the order passed by the original authority and appellate authority, affidavit in opposition is essential. Considering the fact that the bank guarantee has already been encashed, which was furnished to the tune of rupees, about
the total amount, my lord.
Bank BG, how much?
No, roundabout, my lord.
Already, you say substantial amount. We direct affidavit in opposition to be filed not later than 14th November 2025. Correct?
My lord, bond of 3 lakhs, your lordship, 3,76,000, page 112.
You can file it within 14th November.
14th November, we will. Because your lordship, in the appellate authority's order, it's very palpable that plethora of allegation has been raised against him. So these allegations have to be dealt in affidavit.
My lord, I'll submit, my lord, as regards to fabrication, my lord.
And reply, if any, by 26th of November 2025. Let the matter appear before the appropriate learned single bench in the daily list on 28th November. Next.
As regards to, my lord, fabrication, what has come down from your lordship, my lord, fabrication, yes.
No, we have not said. Authority has.
No. Authority has said that the work order, my lord, work order subsequently placed is fabricated, not the orders.
Next.
This is my opinion. Because this is against RC cancellation. There was a one-line show cause issued, which is at page number 130, that in case registration has been obtained by fraud. This was the only, there is no inspection report, nothing. At page 130, lordships.
But why you approach the
lordship after appeal? In appeal, lordship, the appellate authority improved upon the facts and stated there is an inspection report. But inspection held at our back and we submitted all documents, all possible documents. My lordship, my only grievance today is the show cause proposed a suspension from the date 24th of March 2022. I obtained registration in 2019. I was doing business. Now they have cancelled retrospectively from 2019. Now what has happened? My customers to whom...
No, show cause says 24/3/2022.
But order, lordship, can you take cancellation order at page 131?
Page 130 is the show cause.
130 show cause, 131 order. Next page. The effective date of cancellation is 9/5/19. Now, lordship, I have attached what my difficulty, lordship.
No, what is the allegation?
No allegations of registration obtained by fraud. But what means? Nothing, no detailed annexion, nothing, lordships. This is the show cause, this is the order.
But same day.
No, not the same day, lordships. Not the same day,
not the same. 24/3/54.
24/3 and 5/4, lordships. After 7 days. But lordships.
And you didn't give your reply.
Lordships. What reply will I give to this one line show cause?
After
there
that,
has to be a show cause.
Show cause for revocation. After that, revocation has been filed. Show cause for revocation of cancellation. Then after that, appellate authority. So there has been
in no period I was given any details as to what has happened.
Right. Where is your revocation application?
So revocation application in portal we have to write. We have written. Now they have given a show cause of a revocation.
Page.
That is a lordship page 132. They say you produce these supporting documents, upload these documents.
Supporting documents, upload documents, existence, span of tenant, landlord, electricity bill, final, so on, so on, so.
Now, lordship kindly sees the date of hearing was given as 10/5/22. Lordship, we sought an adjournment. We appeared on 21st of May 2022 and sought an adjournment.
21st of May.
May 2022.
That is not disputed.
That is not. That is in appeal order. It has been tackled.
Accepted.
Now, lordships, next day, because it was an oral adjournment, the next day order comes to be passed. The order is at page 133.
133 rejected.
Rejected. I file an appeal. Not that appeal I filed at page 134. APL 01 along with the detailed appeal. Lordship kindly takes the appeal order. The appeal order starts at 144. The detailed appeal order. Lordship, this first paragraph, B facts, page 144. On 21/3/22, physical verification, Lordship, behind my back.
And these were not
never given, Lordships. And now, Lordship, what has happened in the meantime in the appeal? Lordship, may kindly take this, the third paragraph, the second last paragraph of the appeal order. Shri Naskar told that she was one of the landlords, but she was staying abroad for last 10 years. Page 144, last paragraph, last line. Shri Naskar told that she was one of the landlords, but she was staying abroad. So there is no dispute that my landlord is not in existence. Appeal order writes all those things. But Lordship, I have not even given an opportunity. My only predicament, Lordship, let them, if they want to cancel also, they can cancel from the day of suspension. Now, my customers, I have attached my electronic cash ledger. I have paid 20 lakh rupees through cash and 20 lakhs through credit. Now, my customers are issued show cause notice for the period 19/20/2021 that you reverse ITC. Lordship, that show cause also I have attached, Lordships. Kindly takes that at page 205. Chhattisgarh department, because it was an interstate supply, Chhattisgarh department has issued a show cause to my client, Tirupati Construction.
Page
205, Lordships. The detailed show cause is at page 207. Page 207 would be appropriate, Lordships. Lordship, there is a box. After the table, there is a box. Outward supply of Messrs. Riddhi Enterprise for the month of June to March 21 shows supply of this taxable value to your fund. Messrs. Riddhi has been cancelled suo motu from 9/5/19. Therefore, you reverse ITC.
Sir, one thing. First is show cause notice proposed a date for cancellation. Order of cancellation was retrospective. That is bad. Secondly, the basis for which show cause was issued was never disclosed, and for the first time,
appeal order.
In the appellate order, it has come to light.
Lordship, Delhi High Court through an authoritative judgment, I have attached those judgments also. It has been held that when the suspension has been proposed, no, the retrospective cancellation is bad. Lordship, may kindly take that on that page 165.
Factually, there is something which I would like to place. Your Lordship kindly comes to page 90.
165.
Factually, there is the
165
observation and finding. Observation and finding. Page 9 in the Lordship
appeal order.
Appeal order.
Where appeal order.
Your Lordship.
Page 133.
133.
It starts at 144. The detailed appeal order.
Observation and finding. If your Lordship comes to
observation finding starts at 145 last.
145 last paragraph, your Lordship.
In the meantime, we took new
observation in the second paragraph. That is the issue, your Lordship. The claim of the appellant took a new place of business with effect from 2/5/2022 is not material. The show cause notice.
Lordship, in the meantime, I applied for new, but I could not update in the portal because I was suspended. When my portal is suspended.
No, initially. Chitpur. That was the original.
And for that, there is a rent agreement. There is no dispute. The landlord is there, which has been confirmed in the appeal order. Now, in the meantime, when the suspension was active, Lordship, I applied for an additional place. Now, additional place I cannot update in the portal unless the portal is active. So I produced all my documents, my rent agreement, and the new place all agreements. The learned appellate authority says these are immaterial. This is for your new place which you have never added. How can I add when I am not allowed to add? Plus, lordships, the show cause, lordships, one line, some opportunity. Now, lordship, they don't want to do business, I will not do business. That's fine. But the issue is, lordship.
No. Unless you do business, they can't collect tax.
No, lordship, lordship, I have shown you that show cause at page 205. My customers, 20 lakh rupees, the department is saying you reverse because your state has cancelled the registration, suo motu backdate. No proposal in the show cause to do that. And this particular aspect, lordships, has been kindly takes that 165 once. It has been dealt in very detail by the Honorable Court's lordship that how can you do something which was never proposed?
That is wrong, sir. Retrospective is wrong. Non-disclosure of the reasons is also wrong.
Lordship,
For the
retrospective is
first time, he is made known of the allegations in the appellate order.
Lordship, retrospective there is in the statute itself only.
That has been held to be bad in law. Several decisions.
Also.
Several
Retrospective
decisions.
from the, because if
See now, it has a cascading effect. His
My
customer are now being issued show cause notice, their credit will be denied. Not all, it will result in multiplicity.
Lordship, in these cases, in these type of cases, if there is no retrospective cancellation, then generation of fake ITC is also very big. It becomes a very big issue, Your Lordship.
No allegation of ITC. They say you are not existent.
At the
Appeal
place of
letter
business.
says the place of business is there. The landlord says, yes, this person, the landlord is there.
And he has got ample opportunity, Your Lordship, in revocation, order of revocation, before show cause notice of revocation. In 10/5/22, he was asked to appear. And nowhere I can find the adjournment. He has asked for any adjournment.
Oral adjournment. I told lordships. Oral adjournment on 21st.
That I have to take.
Which has been dealt with in the appeal order. Appeal order.
But you filed the writ petition after 2 years.
Lordship, we were waiting for tribunal because that time council meeting had happened and it was that tribunal is being formed. But because the tribunal couldn't came, therefore, because now this notice is being started issued. Lordship, kindly takes the 205 date. 207, 205, Lordship, this is dated 2025, 27th of March 2025. So now when this all started happening, we were waiting for the tribunal.
To your customer.
To my customer.
Therefore,
I have to, I was waiting for tribunal because from that day I cannot do business. Now my retrospective cancellation, Lordship, and Lordship, I have attached my credit ledgers. Kindly takes once, Lordship. My, Lordship, 104 once. I have attached my detailed electronic cash ledger and credit ledger showing how much payment I made in cash and credit.
All right, please come. This intra-court appeal by the writ petitioner is directed against the order dated 16/7/2025 in WPA 8144 of 2025. By the said order, the learned single bench did not grant any interim order in favor of the appellant, but directed affidavits to be filed. The appellant being aggrieved by such order has preferred this intra-court appeal. Since the appeal as well as the writ petition lie in a very narrow campus, with the consent on either side, the writ petition as well as the appeal are taken up for disposal by this common judgment and order. In the cost title, you have to show the writ petition and the appeal. Prospective cancellation, correct provision. And you have to contact to call for the writ. Otherwise, in the CAS, the writ will be shown as pending. For such purpose, the writ petition is taken on the days list.
We will discuss it.
The appellant challenge, the order passed by the appellate authority, affirming appellate authority, namely,
Senior Joint Commissioner.
No, namely, the Senior Joint Commissioner, North Circle and 24 Pargana Circle, dated 21/6/2022. No.
35/23, Lordship, page 143.
On 30/5/2023, 30th May 2023, by which the appeal was dismissed, affirming the order of cancellation of the appellant's registration with retrospective effect. The learned single bench opined that the writ petitioner has has approached the court after a period of 2 years after the order was passed by the appellate authority. The explanation offered by the appellant is that since the tribunal was to be constituted, the appellant had awaited the constitution of the tribunal, but as a consequence of rejection of the appeal, the appellant's customers received notice during March 2025 proposing to recover the tax on the ground that the appellant's registration has been cancelled retrospectively, which prompted the appellant to approach the learned writ court. In our view, the explanation offered appears to be reasonable, and therefore the writ petition cannot be thrown out on the ground of delay or laches, more particularly when the tribunal is yet to be constituted. Full stop. For the purpose of disposal of the appeal and the writ petition, disputed questions of fact need not be gone into, and the documents as it stands are required to be perused. The authority, namely the Assistant Commissioner, issued show cause notice to the appellant on 24/3/2022 for cancellation of registration on the ground that registration has been obtained by means of fraud, willful misstatement or suppression of facts. The license was suspended with effect from the said date of issuance of show cause notice, namely 24/3/2022. 2022. The appellant was directed to appear before the authority on 30th of March 2022. Since no reply was submitted by the appellant, the authority, namely the Assistant Commissioner, by order dated 5/4/2022, cancelled the registration with retrospective effect, that is from 9/5/2019. The appellant nine five 9/5/2019. The appellant filed an application for revocation of
29/4/22, which can be verified at page 132, Lordships. Page 132, application reference number dated 29/4/22. That is my revocation application number.
They filed an application for revocation. That is not required.
Not
for revocation of the order of retrospective cancellation of the registration. Show cause notice was issued on the said application dated.
This date is Lordship show cause 2/5/22.
2/5/2022. The application was rejected, stating that reply to the show cause has not been filed within the time permitted. The case of the appellant is that they appeared before the authority and sought for adjournment, and a letter was also given, but without adjourning the matter or without considering the request for adjournment, the application was rejected. Having left with no other alternative, appeal was preferred before the appellate authority. The appellate appeal has been dismissed by order dated 30/5/2023. And on going through the appellate order, we find for the first time the appellant has been made known of the allegations which are against him as made by the department. Full stop. At no earlier point of time, the appellant was put on notice about such allegations. In fact, the appellate authority has noted the documents filed by the appellant, but has stated that the documents are not related in any way to the instant case. The explanation offered by the appellant is that in the meantime, there was an additional place of business. Since the registration was cancelled, details could not be uploaded in the portal. Furthermore, it is pointed out by the learned advocate for the appellant that in paragraph 4 of the appellate authority's order, the appellate authority records that one Sri Naskar told that she was one of the landlords, but she was staying abroad for the last 10 years. If this is so, then the identity of the landlord cannot be disputed by the department. In any event, issuance of show cause notice is not an empty formality, as the noticee is entitled to have an effective opportunity to put forth their submissions. Where is that Supreme Court Oryx?
Lordship, Oryx is. Lordship, I have Oryx. I have not addressed, Lordship.
In this regard, it will be beneficial to. In this regard, we take note of the decision of the Honorable Supreme Court in Oryx Fisheries Private Limited versus Union of India, 2010-13 SEC 427, wherein the Honorable Supreme Court pointed out that while reading a show cause notice, the person who is subject to it must get an impression that he will get an effective opportunity to rebut the allegations contained in the show cause notice and prove his innocence. It has been further held that if on a reasonable reading of a show cause notice, a person of ordinary prudence gets the feeling that his reply to the show cause notice will be an empty ceremony and he will merely knock his head against impenetrable wall, INPENETRABLE wall of prejudged opinion, such a show cause notice does not commence a fair procedure, especially when it is issued in a quasi-judicial proceeding under a statutory regulation which promises to give the person proceeded against reasonable opportunity of defense. As pointed out earlier, in the show cause notice, the only allegation is that the registration has been obtained by fraud, willful misstatement, or suppression of fact. The show cause notice is absolutely vague and does not specify any details, nor does it state whether the allegation is that of fraud or of willful misrepresentation or of suppression of fact. Therefore, the entire edifice of the proceedings has to collapse because of the defective show cause notice. At a subsequent stage of the proceedings or at an appellate stage, this inherent defect, which is a jurisdictional error, cannot be rectified. You are referring some Delhi judgment.
Lordship, that is at page 165 on the issue of retrospective.
That apart, we had pointed out that the cancellation of the registration has been made with retrospective effect. Full stop. In the show cause notice, these authorities suspended the license with effect from the date of issuance of show cause notice, and there was no proposal in the show cause notice that the cancellation of the registration is proposed to be done with retrospective effect. Which paragraph?
Page 165, Lordship, it has been, Lordship, para number 6, a judgment of the Delhi High Court has been taken into account. And then, Lordships, in that particular judgment, page 166, para number 9 and 10. 9 and 10. May I read, Lordships?
Page.
Page 166. Para number 6, main para, inside that a judgment has been referred. Then that judgment, para 9 and 10. In terms of section this. May I place before? Para number 10, it is important to note
in this regard, we take note of the decision of the, that's a division bench.
Division bench.
Ramesh Chandra.
Bench composition, I will just check. It is Delhi only, Delhi High Court.
Take note of the decision in Ramesh Chandra versus Assistant Commissioner of Goods and Services Tax, Dwaraka Division, CGST Delhi and another. What is the citation?
The citation is in.
Get the citation.
I will just get.
In reported in so and so. Wherein the court took into consideration section 29 within bracket 2 of the CGST Act 2017, which empowers the proper officer to cancel the GST registration of a person from such date, including any retrospective date, as he may deem fit, if the circumstances set out in the said subsection are satisfied. The court held that registration cannot be cancelled with retrospective effect mechanically, and it can be cancelled only if the proper officer deems it fit to do so. Full stop. Such satisfaction cannot be subjective, but must be based on some objective criteria. Full stop. It was further held that merely because a taxpayer has not filed the returns for the said period does not mean that the taxpayer's registration is required to be cancelled with retrospective effect or retrospective date also covering the period when the returns were filed and taxpayer was compliant. Furthermore, the court also took into consideration the consequences and effect of such retrospective cancellation on the taxpayers' customers, and it was held that taxpayers' registration can be cancelled with retrospective effect only where such consequences are intended and are warranted. In the case on hand, nothing is forthcoming from the department as to under what circumstances such power of retrospective cancellation was resorted to. What was apprehended by the Honorable Court in Ramesh Chand has occurred in the assessee's case since his customers have been issued notices for recovery of tax and penalty and interest. Therefore, as pointed out earlier, if there is an inherent defect in the show cause notice, the defect cannot be cured at any stage, a subsequent stage of the proceedings, nor before the appellate authority. That apart, the department cannot be given a second lease of life to resurrect the matter once over again by issuance of a fresh show cause notice. For all the above reasons, we find that the retrospective cancellation of the appellant's registration and the confirmation and order passed by the appellate authority confirming such retrospective cancellation are bad in law. For the above reasons, the appeal as well as the writ petitions are allowed, and the orders of cancellation, retrospective cancellation of registration is set aside, and the authorities are directed to restore the registration and with retrospective effect, and also consider the application filed and thereafter consider the application filed by the appellant for additional place of business in accordance with law.
Is the citation?
Let him come down.
I will just give the
Lordship, Lordship, since the matter is over and Lordship is the Chancellor's representative of my alma mater, academic question regarding this thing, that Ramesh Chandra, this case which I have referred, I was going through this, that was cancellation on the basis of non-filing of returns, which is completely from what I've seen from my learned friend has referred.
Please complete.
So cancellation of non-filing of return is completely different from registration has been obtained by means of fraud.
That is so vague, sir. See, in Income Tax Act, these notices cannot stand. See, when there are options, fraud, misstatement, fraudulent. What is the third one?
Fraud, willful misstatement, or suppression of fact.
So, a fraud may encompass both. A misstatement will not encompass. Willful misstatement may not be fraud.
Not so. They are disjunctively there. Has to be read.
Univer Textile Supreme Court in excise cases in when 73(11)(a) first provision they have invoked. Your Lordship has decided so many cases in the original.
Lordship, we get to learn from my learned friend. It's always there.
I don't know when I will next appear during these 2 days, but it has always been a pleasure addressing.
Alright, today all 14 matters disposed of. Then 15 adjourned after vacation.
15, Lordship. I am
after
handicapped.
Because Tanay wanted to make some.
He wanted to make submission, Your Lordship.
I am ready with that submission. Single
It's
Your Lordship, I crave leave to mention one matter, Your Lordship. This is Pratyush Jhunjhunwala, Your Lordship. Your Lordship, the reason I'm mentioning, my Lord, is that there are appeals that I want to file, Your Lordship. These are appeals which are being filed against the orders passed by the tribunal, Your Lordship. It's a common order, my Lord, of two assessees comprising of 5 years. My lord, I have been given one certified copy for each of the assessees. I'm being stopped by the filing department from filing the appeal, saying that, my lord, the certified copies are available only for your lordship, since it's only for 2 assessment years.
Pratyush Jhunjhunwala, no?
Pratyush.
Pratyush,
My
what
lord.
you do is ask your junior to come tomorrow with the papers. We'll issue us appropriate direction.
I apologize, my lord, and I am grateful, your lordship, and I apologize for the inconvenience, my lord.
Tomorrow. So that he has to make an endorsement. We will tell what the court master has to make an endorsement, then he will.
Lordship, I seek indulgence since Mr.
I'm
Chakraborty is
grateful.
not there. Kindly don't do it after vacation. Mr. Chakraborty will want to do the matter before you, your lordship only. So kindly don't make it after vacation, your lordship.
Thursday, 15th Thursday, if your lordship,
Lordships,
Let it come on Thursday, let us.
much obliged.
much obliged.
अपन आगे बोले ना कौन को अच्छी तरह बोलते हो कि 5 कोर्ट बीच ना आगे बोलते तो चीफ सामने नहीं बोली अरे तुम इतना लेट बोला ना चीफ बोला कल करेगा हाँ अरे तुम इतना लेट करके बोला है ना चीफ बोल रहा है कल करेगा आज नहीं करेगा तो तुम्हारा कोई पेपर कोर्ट में नहीं है